So we are coming to section 210. So it is only in the court having original jurisdiction, proceedings for taking cognizance of an offense may be instituted. So we have seen the meaning of the word cognizance first. Cognizance. I have told you that it is not application of mind. Mere application of mind is not taking cognizance. The literal meaning of the word cognizance, to take cognizance, is to become aware of. So the moment the magistrate reads or peruses the complaint, he applies his mind and he becomes aware of the offenses, provided the complaint discloses commission of an offense. So when the complaint discloses commission of an offense, then there are two options for a magistrate. One, to forward the complaint to the magistrate under section 156(3). There is no corresponding provision in the BNSS, unfortunately. And or to decide that, yes, I am not sending it to the police. I am going to inquire into it. I myself will deal with this complaint. This position, that is where the magistrate decides to deal with the complaint himself, it amounts to taking cognizance. The latest decision on the point is AR 2024 Supreme Court 3863. Yes, I am giving you this meaning. Only in relation to a complaint. But in relation to a final report or police report, the position is different. We will discuss it later. So far as a complaint is filed, the magistrate is said to have taken cognizance only after application of his mind. He decides to deal with the case himself. So what is the next step so far as he is concerned after taking cognizance? He has to record the sworn statement of the complainant and inquire the case into by himself. So taking cognizance is nothing but a mental exercise which is manifested by the course taken by the magistrate. The moment he says that I will record this sworn statement of the complaint, even though he did not record it on the same day, it clearly shows that he has taken cognizance. And once cognizance is taken, magistrate cannot forward the complaint under section 156(3) to the police. A complaint can be forwarded to the magistrate, police, only before the pre-cognizance stage. Not before that, not after that. So application of mind is necessary even in the case where the magistrate does not take cognizance. Only after he applies his mind to the allegations in the complaint, so that he may know whether the allegations constitute an offense. If the allegations do not constitute an offense, the only option before the magistrate is to reject the complaint, as there is no valid institution of the proceedings. The magistrate cannot even entertain it. You can see AR 2024 Supreme Court 54. In every case, he has to apply his mind. But merely because he has applied his mind, it cannot be said that he has taken cognizance. So cognizance does not mean application of mind. It is something else. It is the decision taken by the magistrate in his mind to proceed under the subsequent sections of the chapter 15. So next we have to understand the meaning of the word court having original jurisdiction, court of original jurisdiction. Court of original jurisdiction means it is the court in which a proceedings has to be instituted for the first time for taking cognizance of an offense. So which court under the BNSS is court having original jurisdiction? And what is the difference between civil law and criminal law so far as original jurisdiction is concerned? In civil law, CPC section 15, you get the answer. What does section 15 say? That every suit shall be instituted in the court having in the court of the lowest grade, which is competent to try the suit, take cognizance of the suit. So cognizance is there even in civil cases, and the suit should be instituted in the lowest court, competent to take cognizance of the matter, cause of action. But when we come to criminal law, it is not so. There is a difference. In BNSS or CRPC, there is no provision to the effect that proceedings shall be instituted in the court, in the lowest court having jurisdiction, because there is no question of concurrent jurisdiction. Powers are different. Then where will we get the provision indicating that it should be filed or instituted in the court having original jurisdiction? So if any section says that a particular proceedings, especially a proceedings for taking cognizance of offense, shall be instituted only in a particular court, it means that is the original court having jurisdiction for taking cognizance of the offense, not for other matters. So is there any provision which says that a complaint, that is the proceedings for taking cognizance, shall be instituted in a particular court? Then if there is an answer, that means that is the court having original jurisdiction. So that for that we have to read subsection 2 of section 210. Yes, subsection 2 of section. Yes. The chief judicial magistrate may empower, sorry, it is not a subsection. Yes, subsection 2 of section 2. The chief judicial may empower any magistrate of the second class to take cognizance on subsection 1 or such offences as are within his competence to inquire into trial. So we know that second class magistrate is the lowest grade. Magistrate is the lowest grade. But here it says that only if a second class magistrate is empowered to take cognizance on a complaint, it can be instituted. So we can say that second class magistrate court is not the ordinary court. It is not the ordinary court having jurisdiction. Now you come to section 210 subsection 1. Subsection 1. Yes, this is the section which says which court has original jurisdiction. Original jurisdiction so far as cognizance on a complaint may be taken. Subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class, especially empowered in this behalf, under subsection 2 may take cognizance of any offense. So the court which is invested with the power to take cognizance of an offense on a complaint, again I stress the word complaint, on a complaint, is judicial magistrate of the first class. Unless a second class magistrate is empowered to do so, he cannot take cognizance of an offense on a complaint. So in the ordinary course, it is the first class magistrate who is invested with the power to take cognizance, and that court is the court having original jurisdiction for taking cognizance of an offense on a complaint. Yes. See, section 210 subsection 1 says that subject to the provisions of this chapter. Why that subject to the provisions of this chapter? I am going to explain. Any magistrate of the first class and any magistrate of the second class is specially empowered in this behalf. Unless there is a special empowerment, second class magistrate cannot take it. And subsection 2 may take cognizance of any offense. So which court is empowered to take cognizance of an offense is given in subsection 1 of section 2. That is a magistrate of the first class or a magistrate of the class if he is empowered. So that is the court having original jurisdiction, because it is in that court only you can institute a complaint. The rest of the section also we can read. Subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class specially empowered in this behalf under subsection 2 may take cognizance of any offense upon receiving a complaint of facts including any complaint, etc. So the court which is invested with the power to take cognizance on a complaint is judicial first class magistrate or specially empowered second class magistrate. So far as taking cognizance of an offense on a complaint is concerned, the court having original jurisdiction is magistrate, court of magistrate. What does it mean? It means that no other court can entertain a complaint for taking cognizance. For other purposes, it may there. So far as taking cognizance is concerned, the magistrate having jurisdiction to do so is the court which is having jurisdiction to do so is court of the magistrate. It is the original court having original jurisdiction. That means a complaint cannot be filed in a sessions court. There is a specific provision dealing with it. That is a section 213. Because we know the hierarchy, the lowest one is a second class magistrate. Unless he is specially empowered, it cannot entertain a complaint. Then just above it, we have first class magistrate, and just above we have sessions court. So the question is, why a complaint cannot be filed in a sessions court? The answer you will get in section 213. Except as otherwise expressly provided by the Samhita or by any other law for the time being in force, no court of session shall take cognizance of any offense as a court of original jurisdiction. See? So there is a specific bar for a sessions judge, sessions court, to take cognizance on a complaint. So it clearly says that a sessions court, so far as a complaint is concerned, is not court of original jurisdiction. Then, but it can take cognizance, it can proceed with the case, entertain a complaint or some matter, if the matter has been committed to it by a magistrate under this Samhita. So sufficient for us to say at this stage that the court having original jurisdiction for taking cognizance on a complaint, again I stress the word complaint, is magistrate court. Sessions court cannot take cognizance on a complaint. So whether it is on a complaint or otherwise, a sessions judge is prohibited from taking cognizance of an offense. Even on a complaint or even on a police report, a sessions judge is not supposed to take cognizance unless the case is committed to that court. What is the meaning of the word committal? We will explain. So this prohibition, you can see there are two decisions. 1983, volume 2 SEC 372. A year 2012 Supreme Court 1485. So not only on a complaint, but also on the police report, a sessions judge cannot take cognizance at the court of original jurisdiction unless it is committed. So that means you have to come to the sessions court only through the magistrate court. You cannot directly approach a sessions judge with a complaint or a police report. This is subject to exceptions. Which are the exceptions we shall see later. So for the time being, for our purpose, you just understand that a complaint has to be instituted for taking cognizance of an offense only in a magistrate court. And that court is the court having original jurisdiction. So this section says that unless there is a committal, a sessions judge cannot entertain a matter. So what do you mean by committal? What do you mean by committal? There are beginners, and for other understanding, I would tell you that a complaint or a police report has to be submitted initially before the magistrate in sessions cases. Even in sessions cases, the complainant has to file, or in the case of police report, the police have to file the police report in the court of the magistrate. Even police cannot directly approach a sessions court. So there is no direct access to a sessions court. So hierarchy we have seen: second class magistrate, first class magistrate, sessions judge, high court. So it is just like a multi-storied building. You have to first come to the ground floor, then to the first floor, then to the second floor, and then to the third floor. You cannot have direct access to the top floor. But this is subject to exceptions. Okay. So the proceedings have to be filed, submitted, even in sessions cases, before a magistrate only. And what is the duty of the magistrate? The magistrate will check whether the papers are in order. All the documents have been filed. Yes. So whether it is a complaint case or whether it is a police case, the party can approach only the magistrate. There is no direct access to the sessions court. A party has to possible to move slightly to the right. Yes, it is my problem. Sometimes I tilt my head. Yes. So no party can directly approach a sessions court. There is no direct access because it is on the top floor. So you cannot have direct access to the top floor. You come to the lowest court, that is the ground floor, magistrate court, then sessions court, second floor, or magistrate second class, third floor it is. So this is what is contemplated by section 213. So what is meant by committal? Because section 213 says that if it is committed by a magistrate court, then the sessions court can take up the matter. So a sessions court can take up a criminal matter, police report or complaint case, only if there is a committal order by a magistrate. So the question is, what is meant by committal? Committal is When a police report or complaint is filed in a magistrate court, which discloses commission of an offence triable by a sessions judge, sessions court, the duty of the magistrate is to check whether the papers are in order, whether all the documents which are necessary for the trial of the case have been filed. If everything is in order, his duty is only to send up the documents to the sessions court. He cannot pass any other order. He will send up the documents, the file, to the sessions judge. This sending up the file materials along with this police report and the complaint is called committal. So committal is a process of sending of these records by a magistrate to a sessions court which is competent to try the case. It is done by, no, there is no transfer. Transfer is always from one court of equal strength to another court, equal grade to another court. Sessions judge has no, magistrate has no power to transfer a case. Transfer is given by the some of the provisions towards the end of this BNSS, not before that. This is just, it is a statutory duty of the magistrate to send up the police report or the complaint along with the records after his satisfaction that, yes, the materials disclose commission of a sessions offence. So, why the process of committal, sir? The process of committal is there because it is only one kind of screening. Unnecessary materials should not reach the sessions judge, which is of a higher grade. So there is a screening. The process is a screening process. The magistrate will inspect the documents, the materials, and decide whether the allegations constitute commission of a sessions offence. So if the allegations do not constitute commission of a sessions offence, the magistrate will not send it up to the sessions court. He will try it himself. He will try it himself. So this process is called sending up the magistrate applying his mind, perusing the documents or records, and apply his mind for what? Apply his mind to see whether the allegations constitute a sessions offence. This process is called committal. Committal. And the magistrate has to do it by passing an order of committal. Order of committal. You can read section 232 CRPC. 232 CRPC. Sorry, not CRPC, but BNSS. I just wrongly mentioned it. (232). Yes. See, magistrate can grant bail in sessions cases, except in two instances, which I have already given you. But in the case of default bail, it is immaterial whether it is a magistrate offence or sessions offence. Default bail, the magistrate is bound to give irrespective of the nature of the offences. Even in that case, default bail, the accused is indicted. So 232. 232. 232. When in a case instituted on a police report or otherwise, the accused appears or is brought before the magistrate, and it appears for the magistrate that the offence is triable exclusively by a court of session. So The magistrate, after perusing the records, after applying his mind by perusing the records, materials placed before him, he comes to the conclusion that a sessions offence has been disclosed. Then what he should do? He shall commit, after complying with the provisions of section 230 or section 231, that is giving records etc. to the accused, the case to the court of session. So here commit means send up the case to the sessions court, and subject to the provisions Sahida relating to bail, remand the accused to custody until such commitment has been made. So here what we have to notice is only this: the process of committal is mentioned in section 232A. So it is sending up the records to the sessions court, because the case involves commission of a sessions offence. Yes. So we have seen that a sessions judge cannot directly take cognizance of an offence. It has to come from the magistrate court. The magistrate court has to satisfy itself that a sessions offence is involved, and he has to send up the materials to the sessions judge with his order of committal. So sending up the documents, sending up the records and the materials to the sessions judge for trial is called committal, and that is done by the process of passing a committal order. So after getting these records, what the sessions judge is supposed to do? What the sessions judge is supposed to do? Magistrate sent up the records, right? Cognizance. He has to take cognizance. So there is a controversy whether cognizance can be taken twice. Cognizance taken by a magistrate, already taken by a magistrate, then there is no question of the sessions judge taking cognizance again. Such a view has been expressed in one Supreme Court decision. There is no question of sessions judge taking cognizance again. I will give you that decision, but remember that it is not the settled position. Year 2002 Supreme Court, 2784. But a different view has been taken, that is year 2016 Supreme Court, 2266, which says that the sessions judge takes cognizance after it has received the committal order. So double cognizance. What is the legal position? Let us analyze. Again, section 232. It will give you the answer. Whether sessions judge takes cognizance after committal. Section 232. I will give you. See, magistrate takes cognizance even in a police report or complaint which discloses commission of a sessions offence. The duty of the magistrate is to send up the records to the sessions court. So magistrate has already taken cognizance. So a judge has expressed the view that only once cognizance can be taken in a case. That means even if it has been committed by the magistrate, and since the magistrate has already taken cognizance of the offence, the sessions judge, there is no question of the sessions judge taking cognizance. This view is wrong. I have given you the decision, year 2016 Supreme Court 2266. So let us see whether after the committal order, yes, after the committal order, whether the sessions judge takes cognizance. What does the BNSS say about it? See, read it. When in a case instituted on a police report or otherwise, that is complaint, the accused appears or is brought before the magistrate, that on summons or otherwise, arrest, and it appears to the magistrate that offence is triable exclusively by the court of session, he shall commit, after complying with the provisions of the case to sessions court, subject to the provisions of this Samhita relating to bill, remand the accused to custody until such commitment has been made. Commitment has been made. Now you read section 213. So it has reached the sessions court. What does section 230 say? The 213. 213. Yes. See, the heading itself shows cognizance of offence by court of session. It reaches the court only after committal. 232. This state, though it is in section 213, and the order of committal is mentioned in section 232, the first stage is section 232. So, section 232, under section 232, a sessions judge receives the order. Then 213 applies. It says that, except as otherwise provided by this Samhita or by any other law for the time being imposed, no court of session shall take cognizance of any offence. So, what does it mean? What does it mean? The sessions judge takes cognizance in a committal also. So, it is clear that when a case is committed to a court of session, the sessions judge takes cognizance. So, the first decision of the Supreme Court, 2002 Supreme Court 2784, patently wrong. Patently wrong. So, the section itself says that the sessions judge takes cognizance of an on committal of a case. The heading itself says cognizance of offence by court of session. And always remember that. Under private complaint, two procedure is the same. The magistrate has to pass order of committal. Order of committal. So we will just discuss it later. So for the time being, you just understand that even in complaint case and police case, unless there is a committal order by the magistrate, before whom only the proceedings can be filed initially, a sessions judge can take cognizance of the offence. Yes. So, but this section says, except as otherwise expressly provided by the Samhita. So let us see whether there is an exception to this rule. This contains the ordinary rule. The ordinary rule is that unless there is a committal order by the magistrate, because magistrate is the original court having jurisdiction, court having original jurisdiction. So you first approach magistrate. He will send it up to me after screening. So, but the ordinary rule, there are exceptions, is the order of magistrate committing the case to sessions court amounts to taking cognizance. No. Only after magistrate has taken cognizance, he can proceed with the case. He can proceed with the case. He can commit the case only if he has taken cognizance of the offence. That means he has taken judicial notice, and he decides, or he comes to the conclusion, yes, the allegations constitute a sessions offence. It has to be tried by a sessions court. I cannot do anything. So I will send it up to the sessions court. That is taking cognizance. Only after the magistrate has taken cognizance, he can commit the case. So here's ordinary rule. You come to the sessions court only through the magistrate court, because that is the court of having original jurisdiction. Okay. So Let us see why it is stated, except as otherwise expressly provided. Is there any express provision in the BNSS to the effect that even without a committal, a sessions judge can take cognizance? Is there any specific provision? There is a specific provision where a sessions judge is right. A sessions judge is empowered to take cognizance even without a committal. Very exceptional case. You can see it in subsection 6, section 222. But section 222, the first part will reveal what kind of case it should be. 222, subsection 1. Prosecution for defamation. No court shall take cognizance of offence punishable under section 356 Bharatiya Nyaya Samhita except upon a complaint made by some person aggrieved by the offence. So this section deals with defamation cases. Criminal defamation. You know that both civil and criminal cases are maintainable in the case of a defamation. So this section deals with the defamation. Now subsection 6. Subsection 6. Sorry, not subsection 6. 234. 234. Notwithstanding anything contained in this Samhita, when any offence falling under section 356, that is defamation, is alleged to have been committed against a person who at the time of such commission is the President of India, the Vice President of India, the Governor of a state, the Administrator of a Union territory, or a Minister of the Union or of state or Union territory, or any other public servant, employed in connection with the affairs of the Union or of a state in respect of his conduct, in the discharge of his public functions, a court of sessions may take cognizance of such offence without the case being committed to it upon a complaint in writing made by the public prosecutor. See, here it says that if the defamed person at the time of commission of the offence, see, at the time of commission of the offence, not after his retirement, not after he ceases to be in that office, is the President of India, Vice President of India, Governor, Administrator of a Union territory, Union Minister, State Minister, Public Servant, etc. in respect of his conduct. So the defamatory matter should have something to do with discharge of his public functions. Then a court of session may take cognizance of such offence without the case being committed to it upon a complaint in writing made by the public prosecutor. So here, it should be filed by a public prosecutor. It should be filed by a public prosecutor, the complaint. So there is no question of police report in a defamation case, whether it is an ordinary man or whether it is a president or other officers. In a complaint, in a defamation, only on a complaint, the court can take cognizance. In the case of president and in vice president, etc., even without a complaint, that means a complaint can be directly filed before a sessions judge. There is no question of any committal. But the application, the complaint should be filed by a public prosecutor. Okay. So it is just like we have seen that in a multi-storied building, floor 1, floor 2, floor 3, there may be a lift. Unless you come to the first floor, you cannot reach the second floor. But here, if it is on the top floor, if there is a helipad, you can directly land on the top floor. So here, even without coming to this first floor or second floor, you can reach the third floor. That is the sessions court. You can directly approach a sessions court with a complaint. provided the complainant is the public prosecutor. The procedure we shall see later. We shall see later. Okay. So this is an exception contained in BNSS that even without a committal, a sessions judge can take cognizance of an offence. Then another exception is given, subject to the expressly provided in this route or special statutes. So there are special statutes which say that even without a committal, a case can be taken cognizance of by a sessions judge. For example, you can see special judges, then SC/ST provision, SC/ST Prevention of Atrocities Act, then special cases NDPS Act. It's also a sessions judge, sessions case. So there are special statutes which provide for taking cognizance by a sessions judge even without a committal. One instance in BNSS, that is defamation of president, etc., but always in connection with the affairs of the state, that is public functions, discharge of public functions. But remember that subsection 2 is only an enabling provision. It does not say that only on a complaint filed by a public prosecutor, sessions court can take cognizance of an offence. Because subsection 6, you can see subsection 6, nothing in this section shall affect the right of the person against whom the offence is alleged to have been committed to make complaint in respect of that offence before a magistrate having jurisdiction or the power of such magistrate to take cognizance of the offence upon such complaint. See? So subsection 2 is only an enabling provision. The president or the vice president need not come to the court. Union minister, state minister, administrator, governor, they need not come to the court. The prosecutor can file a complaint. And this does not mean that they do not have a personal right. The personal right of the defamed person, that is the aggrieved person, is not affected by subsection 2. So subsection 6 says that in spite of that provision, subsection 2, the person, the defamed person, the aggrieved person has the right to file a complaint in his personal capacity before a magistrate. And the magistrate is competent to take jurisdiction. So this is a special provision enabling a prosecutor to file a complaint against an accused who has defamed a public servant in this connection with the discharge of his public functions. This does not take away the personal right of the aggrieved person to approach a magistrate with a complaint or the power of the magistrate to take cognizance on such personal complaint. Right? So we have seen, first we saw that the court having original jurisdiction in entertaining a complaint is magistrate court, whether it is first class or second class, it depends upon the, if it is second class, only empowered magistrate can do it. Then we have seen that the ordinary rule is that a sessions judge cannot directly take cognizance of offence, but this is subject to the exception contained in section 22(1). In the case of defamation of president, etc., if the complaint is filed by a public prosecutor, the sessions court can directly take cognizance. But this does not take away the right of the personal right of the defamed person to approach the magistrate with a complaint. So we have seen magistrate court's power, sessions court's power. Then what about high court? Yesterday we saw that high court is also a criminal court under BNSS. So that's why the section starts apart from the high court. So in addition to the high court. So high court also is a criminal court under BNSS. So Supreme Court is not a criminal court under BNSS. Yes. So what about the high court? Has the high court been empowered to take cognizance of a criminal case as an original court of having jurisdiction. Sessions judge we have seen at least one sentence, one provision is there, one instance is there. But what about the High Court? There is no provision in BNSS empowering a High Court to take cognizance on a complaint or otherwise directly. So far as complaints or police reports are concerned, a High Court is not a court of original jurisdiction. And once it so happened that the chairman of the Bar Council of India, the Supreme Court came to the conclusion that he committed an offense. And the Supreme Court directed registration of a case against him. What does it mean? The Supreme Court took cognizance of the offense and passed the order for proceeding against him. Later, what happened? Later, the Supreme Court realized that they have no power to take cognizance as it is not an original court having jurisdiction. Section 21 says that the offenses under this may be tried by the High Court. May be tried, but there is no empowerment. There is no empowerment. Yes. That's why I told you that it is a criminal court, but there is no provision enabling, empowering a High Court to take cognizance of an offense as a court of original jurisdiction. Even the Supreme Court does not have such power. No, public interest litigation is a different one. That is under the Constitution, not under the BNSS. That is under BNSS. It's not a case of a criminal case. Yes. So, only Magistrate Court has the power to take cognizance as a court of original jurisdiction. Sessions Court, ordinary rule. What is the procedure means? Procedure for what? Procedure for what? For Sessions Court. Sessions Court, committal only. But in the case of exception, you would directly file a complaint. The prosecutor has to directly file a complaint. He need not come through the magistrate. Supreme Court, there is no question of having any original jurisdiction in the case of taking cognizance. Taking cognizance. No. But appeals, revisions, etc., you can go to the Supreme Court. But that is not an original court having jurisdiction. Original court of jurisdiction, neither the High Court nor the Supreme Court is a court of original jurisdiction so far as taking cognizance of an offense is concerned. That's why the Supreme Court realized the mistake and recalled the order. Recalled the order. I have not noted that decision, but I remember that there is such a decision. The Bar Council of Chairman, the chairman of the Bar Council of India was from Uttar Pradesh then. Uttar Pradesh. It is a reported case. It is a reported case. You can get it in Advocates Act. Advocates Act. Yes. Then there are special statutes we have seen. High Court, there is not a court of original jurisdiction. Then there are some instances where any court can take cognizance in a criminal matter of an offense. So we have seen that only Magistrate Court, in exceptional cases High Court, Sessions Court, and never High Court or Supreme Court, because Supreme Court is not a criminal court at all under the BNSS. Then there are some instances where any court can take cognizance. Any court can take cognizance of certain offenses. This is an exception to the ordinary rule. You will get it in section 384, old section 345. 384 BNSS, which says that any court can take cognizance of a particular offense. Yes. Procedure in certain cases of contempt. So it's a case of contempt, criminal contempt. You know that there is a classification: civil contempt and criminal contempt. Civil contempt is nothing but a disobedience of an order of a court. Disobedience of a civil court or a court. That's all. Civil contempt. There are specific provisions for it. But here, it is a criminal contempt. When any such offense, as is described in section 210, section 213, section 214, 215, or the Bharatiya Nyaya Samhita, is committed in view or presence of any civil, criminal, or revenue court, the court may cause the offender to be detained in custody and may at any time before the rising of the court on the same day take cognizance of the offense. See, which court? Civil, criminal, or revenue court. That is executive magistrate court. Criminal court, that is revenue court, can take cognizance. So, except as otherwise provided, first instance we have seen. Here it is a second instance. So, take cognizance of the offense, and after giving the offender a reasonable opportunity of showing cause why he should not be punished under this section, sentence the offender to fine not exceeding 1,000 rupees and to default on in default of payment of fine to simple imprisonment for the term which may extend to 1 month unless such fine is sooner paid. Yes. So this is an exception. It is committing contempt. In the presence of or in view of a court. See, which are the offenses? Offenses mentioned in section 210, 13, 14, 15, 267. So 210, 210. See, omission to produce a document to public servant by person legally bound to produce or deliver it. So, non-production of a document. He is present in court. It is done in the presence of the omission to produce document to public servant by personally legally bound to produce it. So, a person is in custody of a document. He appears before the court with the document. The magistrate says that you produce it. He says that I won't produce it. Then it becomes a contempt of court. That's the 210. The person who is in possession of the document appears before the court with the document, but he does not hand it over to the magistrate. So that is the case covered by section 210. Then section 213, refusing oath when duly required to take oath by a public servant. So the witness is put in the witness box. He refuses to take oath. Unless he takes oath, he cannot be examined under the Oaths Act. So a refusal to take oath is an offense under section 213 and he can be punished under section 384. Even if it is a revenue court, even if it is a civil court. 214. Being legally bound to state the truth and refusing to answer public servant authorized to question. So he refuses to answer, state the truth, and refusing to answer the public servant authorized to question. He refuses. The magistrate asks him, why, or what is the, puts a question to him. He does not answer the question. Then he can be punished under section 214. 215. Refusing to sign a statement made to a public servant when legally bound required to do so. After his own statement was recorded, he refuses to. What do you mean by cases are opposite? Yes. Even after, yes. See, nobody will invoke this provision. This is a drastic provision. But it does not happen. It does not happen in court. Okay. Now it is a 267, I think, the last section mentioned. 267. 267. So let us see what is 267. Intentional insult or interruption to a public servant sitting in the stage of a judicial proceeding. Sometimes this happens. Intentional insult or interruption to a public servant sitting in any stage of a judicial proceeding. Say, magistrate is conducting the judicial proceedings in a court. Suppose someone present in the court smokes a cigarette that is covered by this section. It is covered by section 2, intentional insult or interruption to a machine. Then he interferes, he makes interruptions. Section 267 covered. But what is required is that should be done in the presence of or in view of the magistrate or the court. Suppose somebody standing on the veranda, smokes a cigarette, but the magistrate or the court cannot see it. But the peon of the court says that somebody is smoking on the veranda. This provision cannot be invoked. The magistrate did not see it. So it should be done in view of or in the presence of the court. Then only section 384 is attracted. So section 384 is an exception which says that any court, civil or criminal, or even revenue court, can take cognizance of an offense, the offenses mentioned in this section, provided the offenses are committed in the presence of the court, judge, or in view of the judge. See, somebody is making interruptions. No, it is not a question of smell. The offense is smoking. This offense is not smoking. Merely because the magistrate got smell of this smoke, he cannot punish. So, because I remember such a case arose in Kerala. Somebody was smoking on the veranda of the court. That the subject then invoked this provision. The High Court said that no, you cannot do it because you did not see it. You only saw the smoke, or somebody reported that he is smoking on the veranda. Then this section is not attracted. Section 267 BNS is not attracted. So reported cases in Kerala. So that is why I specifically mentioned that. Yes. So suppose an SDM, executive magistrate, is holding a court. Somebody is talking aloud without any restraint. Then this provision can be invoked. So here it is a summary procedure. It is a summary procedure. We are not discussing this section now. Only I have brought to your notice that this is an exception to the ordinary rule that only a magistrate court, my first class magistrate or second class magistrate empowered, can take cognizance of an offense on a complaint. But here, there is no mention of a complaint. There is no mention of a complaint. It simply says that the magistrate can or the court can take cognizance. There is no question of a complaint here. But complaint can be, otherwise we will discuss it later. At the present, for the present, we need not discuss it. So we have seen, we were discussing taking cognizance till now. Nothing else. We were discussing taking cognizance. For that, which court can take cognizance? That is only a court having original jurisdiction. Ordinary, it is the judicial first class magistrate or the second class magistrate. And exceptional case of sessions court. And in no case, high court. But except on a complaint, even otherwise on a complaint, any court, including civil, criminal, revenue, can take cognizance of an offense mentioned in section 384, provided it is committed in the presence of the court, the presiding judge. Okay. So now let us see, we have seen the meaning of the word cognizance. It is taking judicial notice and deciding to proceed under the BNSS by the judge himself, by the magistrate himself. Yes. Now let us see how do cases originate in a magistrate court? So, unless there is a case before a court, there is no question of the magistrate taking taking cognizance. So, how do cases originate in a magistrate court? Should originate, because it is the first instance court having original jurisdiction. So, how cases originate in a magistrate court? So, let us see. Section 210(1). How cases originate. Subject to the provisions of this chapter, any magistrate of the first class or the magistrate of the class empowered in this behalf may take cognizance of any offense. What is the material? 1. Upon receiving a complaint, that is, upon a complaint. B. Upon a police report. C. Two limbs. C has two limbs. Upon the information received by the magistrate from any person other than the police officer, or the second limb, upon his own knowledge, that is knowledge of the magistrate. So these are the four situations where a magistrate can take cognizance. These are the four instances where a magistrate can take cognizance. The first one is on a complaint. The second is on police report. The third is information received from anyone other than the police officer. The last one is on information. We are discussing each of these situations now. Each of these situations. First one is complaint. So magistrate takes cognizance, can take cognizance on a complaint. So what is a complaint? Section 2H defines a complaint. 2H. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this Samhita that some person, whether known or unknown, has committed an offense but does not include a police report. Explanation. A report made by a police officer in a case which discloses after investigation the commission of a non-cognizance shall be deemed to be a complaint, and the police report by whom such report is made shall be deemed to be the complainant. So, in fact, what is a complaint? It is nothing but an allegation. An allegation is the complaint. Complaint means any allegation. But what should be the allegation? What should be the allegation? What should be the allegation? That somebody has committed an offense. Somebody has committed an offense. An offense has been committed. The person may be known or unknown. The person may be known or unknown. Wait, let us see. See. So, the complaint, the definition of complaint deals with two kinds of complaints. The first is a real complaint. The second is deemed complaint. So, the first one is real complaint. That is, any allegation made orally or in writing. So, what does it mean? There can be an oral complaint. There can be oral complaint before a magistrate. Take a case where an accused is brought before the court under arrest. Then he raises an allegation that I was tortured by the police on my way to the court, and action may be taken against the police. The court cannot insist on his giving the complaint in writing. The moment he makes this oral complaint, it is complete. So the section, the definition itself discloses that the complaint can be oral or in writing. Then it should be made to a magistrate. That means you cannot make it to a sessions judge. You cannot make a complaint to a sessions judge because it has no original jurisdiction. Then, with a view to his taking action under the Samhita, with a view to his taking action under the Samhita. Why? Because some person, whether known or unknown, has committed an offense. So somebody has committed an offense. Action may be taken under the BNSS. Yes. And known or unknown. So it is sufficient to say that my pen has been stolen. My pen has been stolen. That is sufficient. So action may be taken. That is sufficient. It is a complaint. I don't know who committed it. That is sufficient. So here, the thrust is on. You raise an allegation, but it should be viewed that he is taking action under this Samhita. What action? Cognizance. Cognizance. Or forwarding it under section 156(3). So that is the action that is contemplated by, on receiving a complaint, the action to be taken by a magistrate is either forward it to the police under section 156(3) old, or take cognizance and proceed. This is the action to be taken if there is a valid complaint. So with a view to his taking action, and an allegation is made with some other intention, it does not amount to a complaint. So I will give you an example. A young lady, she was a witness in a court. She did not appear on receiving summons. The magistrate issued an arrest warrant against that woman, young lady. And on the next posting date, she appeared. The magistrate asked him, why you did not appear on the last posting date? And her response is this: my husband beat me up. I lost one tooth in my lower jaw. So what does it mean? It amounts to an offense. It amounts to an offense. She has raised an allegation that she was beaten up by her husband and she lost one tooth. So it amounts to an offense. The question here is whether the magistrate can take cognizance, treating it as a complaint. It can be oral also. The complaint can be also oral. She raises an oral allegation that her husband tortured her, assaulted her. The question is whether the allegation raised by her is a complaint. Can anyone give an answer? Why? Why? Why it is not a complaint? See, always ask 3 questions. What, how, why? So you are right. She was giving an explanation for her non-appearance. See, why she raised that allegation? Not with the intention of the court taking action against her husband, but she raised that allegation only as an explanation for her absence on the last posting date. So the magistrate cannot treat it as a complaint, right? So if the allegation has been raised only with the intent of the magistrate taking action under the BNSS, it amounts to a complaint. All allegations are not complaints. All allegations of committing an offense are not complaints, but allegations raised with the view to the magistrates taking action under the BNSS alone amounts to, yes, why it is sorry? Why you showed sorry? that she was beaten up.
So, sir, by mistake, he typed
Yes.
something by mistake
Okay,
in the
okay,
chat.
okay. So it is true that she was beaten up. It is true that that amounted to an offense, but the allegation is not an offense because she raised that allegation, made that allegation only as an explanation for absence in the court on the last posting date. The magistrate is not supposed to treat it as a complaint, right? So this is the significance of those words. That is, with a view to his taking, magistrate's taking action under this Samhita. That is the significance. Then known or unknown, we have already seen. Then, but does not include a police report. So a police report, we have seen what is a police report. Police report is not a complaint. Police report, the definition we can see. Police report. That is a report filed after investigation of a cognizable offense. Police report. Yes, a report forwarded by a police officer to a magistrate under subsection 3 of section 193. That is a cognizable offense. So that is not, police report is not a complaint, but that is subject to an explanation. What is subject to an explanation? What is that explanation? A report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offense shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant. So here, actually it is not a complaint. It is a police report, but it will be deemed to be a complaint. So deeming provision means it is a fiction. Really, it is not a complaint. Really, it is a report because the police conducted an investigation. But the investigation discloses that there is no cognizable offense, only non-cognizable. So then it will not be treated as a complaint. It's as a police report, though in reality it is a police report. It will be treated as a complaint. This is a deemed complaint, and the police officer who files the report is deemed to be the complainant. Clearly, explanation of complaint. See, I am going to explain it. Once we explained it, I remember it. But remember, when we discussed the cognizable offense and non-cognizable offense, we discussed it. A police officer has the power to investigate into an offense only if there is an allegation that somebody has committed a cognizable offense. Cognizable offense. If the allegation is that he has committed a non-cognizable offense, a police officer cannot investigate. So what is the provision? The provision says that the investigating officer, the SHO, shall immediately refer him to a magistrate. You go and file a complaint before the magistrate. I cannot, without an order, investigate the case because it is a non-cognizable offense. But the explanation says that, or the provision says that, if it is a case of involvement of cognizable or non-cognizable offense, it will be treated as a cognizable case. So when there is an allegation that several offenses committed and one of them is a cognizable offense, that means it will be a cognizable case and not a non-cognizable. The police can investigate into both offenses, cognizable as well as non-cognizable. That is 174 subsection 4. 174 subsection 4. Information as to non-cognizable offenses, non-cognizable cases and investigation of such cases. Subsection 4, 174 subsection 4. Where a case relates to two or more offenses, several offenses, of which at least one is cognizable, the case shall be deemed to be a cognizable case. Even though some offences are non-cognizable, it will be treated as a cognizable offence, and the police officer has the power to investigate into every offence. There is no question of separation. At least one of the offences is a cognizable offence. The police officer gets the power to investigate into every offence, including the cognizable offences and non-cognizable offences. That is what section 174 subsection 4 says. So let us take the case where a complaint is made and information is given to a police officer by a particular person. His case is this: I was beaten on the cheek, right cheek, by a person, and I suffered pain. What is the offense? Under IPC, it is a section 223, causing simple hurt. No weapon is used, nothing. He just slammed him, and it caused pain. It is nothing but the simple hurt covered by section 223 IPC. It is a non-cognizable offense. So ordinarily, what the police is supposed to do? Record the matter in the Judiciary. Some person came here, he complained that he was slapped. As this is a non-cognizable offense, SHO has no power to investigate, so he has been referred to the magistrate. Judiciary entry that will close the matter. But this police officer wants to see that this matter is taken up by him for investigation. What he will do? An unscrupulous police officer, he wants to collect some money from this complaint, or he is interested in the matter because of some extraneous consideration, either some political influence, or what he will do? He will say, he will add a cognizable offense. And the simplest thing for him to do is to say that I was wrongfully restrained by catching hold of my collar, by catching hold of the collar of my shirt, and then he slapped him, because 341 wrongful restraint. Wrongful restraint. So that is a cognizable offense. So in such cases, this offense also will be added. And since it is a cognizable offense, the information contains a cognizable offense, it will be treated as a cognizable case, and the police officer can investigate both 341 and 323. But after the investigation, he will honestly report that, see, there was no commission of 341, it was a wrong statement, he was only slapped, only 323. Again, police report will be filed because there is an investigation. A police report will be filed. Every investigation should end in a police report. So he will file a police report. Here, the information contained commission of a cognizable and non-cognizable, right or wrong, is a false allegation, but it contains such an information. And so the SHO got the power to investigate. And after the investigation, the SHO reported that only 323, that is non-cognizable offense, has been committed. This is the situation covered by explanation 2H. Yes. So even though that is a police report after investigation, that report will be not treated as a police report, but a deemed complaint. So it will be treated on the same footing as a complaint, and the police officer the complainant. This is the provision. I gave you two decisions earlier. You can note down these two decisions again. That is 1996, 11 SEC 557, 2010, 15 SEC 725. So what is a deemed complaint? Deemed complaint. In essence, evidential value of that. It has no evidential value. A police report has no evidential value because I have already told you that police report is nothing but the opinion of a police officer. Opinion of a police officer is not of any value. No, it has no value at all. So that is a deemed complaint. So if a question is asked what is a deemed complaint, this is the answer. Or who is the deemed complainant? The answer is that a police officer who files a report after investigation into a cognizable case, reports that only non-cognizable offense has been committed, that the police officer is a deemed complainant. Deemed complaint. So deemed complaint and deemed complaint. So section 2H should be read along with section 2H should be read along with section 174 subsection 4. Yes. So what is the complaint we have seen? Now the question is, there may be documents filed along with the complaint. The documents filed along with the complaint. Suppose a complaint was prepared by a person who was not competent to prepare a complaint. There are some omissions in it. But these facts find a place in the documents filed along with the complaint. So in fact, it does not find a place in the complaint. That is an omission. But it finds a place in the document filed along with the complaint. What is the result of it? The law is that documents filed along with the complaint also will be treated as part of the complaint. See, a complaint was filed, but there was a material omission. So the magistrate cannot take cognizance on this complaint because there is a material omission. But that omitted part is seen in a document filed along with the complaint. So if the document produced along with the complaint is also taken into consideration, the magistrate can take cognizance. So the question is whether the magistrate can take into consideration that document and take cognizance of the offense. No, there is no question of the correctness of the allegation. There is no question of the correctness of allegation at this stage. Taking cognizance only means whether there is a prima facie case. That means whether the allegations constitute an offense. Whether there will be proof for it is not at all a consideration at that stage. Whether the complainant will be able to prove it, it is of no consequence. It is immaterial, irrelevant. So in one decision, the Supreme Court held that documents filed along with the complaint also will be treated as a complaint. So they should be read together. That is 2007 6 SEC 555 555 555. Documents filed along with the complaint also will be treated as part of the complaint. Then, judicial application of mind not a part of the finding whether true or not. No, the truth of the allegations is not at all a consideration at that time. That is to be decided after the inquiry or the trial. Truth of the allegation. The court is not concerned with the truth of the allegation when the complaint is received or taken cognizance of. So also a police officer is not concerned with the correctness of the information. It is sufficient for him to see whether the allegations constitute disclosed commission of an offense. That's all. Truth of the allegation is not at all a concern. Then you must have heard about a protest petition. What is a material omission? Suppose a material ingredient. No, every complaint take. No, there is no question of taking cognizance on every complaint, because I told you that if the complaint does not disclose commission of an offense, then it will be rejected. Then there are other instances where a complaint can be rejected. A sanction is necessary. There is no sanction. Then it is not instituted by a proper person. It will be rejected because there is an institutional defect. The rejection takes place when there is an institutional defect. So merely because the magistrate, the complaint has been filed, the magistrate is not bound to take cognizance of it. Then if it is forwarded to the police, there is no question of cognizance. It will be treated by it will be dealt with by the police. So here, you must have heard about the word protest petition. Protest petition. Protest petition. What is the remedy in a proceeding in a court? Remedy for what? Remedy for what? Joseph? What remedy for what? See, when documents are filed along with the complaint, even if something is lacking in the complaint, that will be queried by the documents. Suppose an essential ingredient, 482 has nothing to do with it. 482 has nothing to do with this matter. Yes. So always remember that documents filed along with the complaint also form part of the complaint. They will be taken together as one document. That's all. That's the principle behind it. Then a protest complaint or protest petition. Whether a protest petition is a complaint. Protest petition. What is a protest petition? Suppose after the investigation, the SHO, the police officer, files a report that there is no evidence for commission of the offense. So they are closing the matter. Closure report is filed. Closure report. No offense is revealed. Or some offenses are revealed, but they are not the offenses alleged by the victim or the informant. They are only less serious offenses, minor offenses. Then in such cases, the victim or the informant can file a petition before the magistrate stating that the investigation is not honest, the investigation has not been effective, the investigation has not been regularly conducted. So that petition objecting to the police report and a petition, I will give you a petition raising an allegation that or raising an objection to the police report is called a protest petition. A petition raising objection to the police report is called a protest petition. And if the protest petition satisfies the requirements of a complaint, the magistrate can treat it as a complaint. Otherwise, it is a mere petition. All the ingredients for a complaint should be there in a protest petition. Then it will be treated as a complaint. Year 2024 Supreme Court. (3863). Year 2024 Supreme Court 3863. We will be dealing with this matter again when we consider the proceedings by the magistrate. Accused can file protest petition. No, there is no question of the accused filing a protest petition. No. The accused has no role because it is in his favor. No accused will file a protest petition because it is in his favor. And if there is a finding against the accused in the final report, there is no question of his filing a protest petition. Yes. Okay. So AIR 2024 Supreme Court 3863 says that if the protest petition contains or satisfies the requirements of a complaint, the magistrate can treat it as a complaint and take cognizance on it. Otherwise, it will continue to have the status of a petition only, not a complaint. A petition other than a complaint. And as you know, a complaint should be a signed document. The complaint should contain the signature of the complainant. Suppose he omitted to sign it. He omitted to sign it. What is the consequence? The view taken by the Supreme Court is that it is sufficient that his sworn statement is taken. So even if a complaint is not signed, if a sworn statement of the complainant is taken, the magistrate can take cognizance of it. An unsigned complaint also can be on an unsigned complaint also cognizance can be taken provided his sworn statement is recorded. That is AIR 2013 Supreme Court 426. Yes. And I have already told you that to constitute the allegation a complaint, it should disclose commission of an offense. It should disclose commission of an offense. And a petition is different from a complaint. Complaints are also petitions, but if they satisfy the requirements of the BNSS, it is called a complaint. It is called a complaint. So somebody filed a complaint, but it is styled as a petition or application. The word complaint is not used. What is the consequence? In the last case, what was held in the last case? Last case is that the complainant failed to sign the complaint. He omitted to sign the complaint. So the question is whether the complaint should be rejected because nobody takes up the responsibility. It is not a signed one. The Supreme Court said that if it is the facts are verified by the complainant in his sworn statement, it is immaterial that the complaint has not been signed. It can be taken on file. That is what the Supreme Court has said in 2013 Supreme Court. So here a complaint was filed, but the label was an application. The question before the Supreme Court was whether it can be taken cognizance of. The Supreme Court said that merely because a wrong label is put on it, you cannot say that it is not a complaint. If it otherwise satisfies the requirements of a complaint, even though it is labeled as an application, it will be a complaint. So wrong use or use of wrong label is no ground to reject the complaint. 2013, Volume 6 SEC 384. Now, we have already seen that there are forms prescribed for certain things. There is a form prescribed for summons. There is a form prescribed for warrant, arrest warrant, attachment warrant, etc. Now the question is there a form prescribed for a complaint? Or can it be in the form of a letter? Can it be in the form of a statement? A mere statement? The Supreme Court held that it can be in any form because no form has been prescribed for a complaint. No prescribed format. AER 2006 Supreme Court 705. Yes, another interesting question arises in this connection is whether a complaint can be amended. Because in civil cases, there is a specific provision for amending a pleading. There is a specific provision, or this is Rule 17, right? So it specifically mentions the power to order amendment, allow amendment. Is it possible for a criminal court to order amendment of a complaint, allow amendment of a complaint? The answer is, in an ordinary case, there is no question of amendment with court permission. That is the question, whether the court can permit amendment of a complaint. Ordinarily, a complaint cannot be amended after it is filed. AER 2008 Supreme Court 3086. So a defect, ordinary rule, a defect in a complaint cannot be cured by filing an amendment petition, by amending it. Amendment petition will not be allowed. So the complaint will not be allowed to amend the complaint. But the rigor was taken away by the Supreme Court later. The Supreme Court said that if the nature of the amendment is simple and does not cause prejudice to the opposite side, the complainant may be allowed to amend it. Take a case where the name of the accused is one Hariharan. His initial is PK. The accused is shown as PK Hariharan. But really his initial was MK Hariharan. The complainant realized it only after the complaint was filed. The question is whether he can be allowed to amend the complaint to correct the mistake in the initial. The Supreme Court held that if the nature of the amendment sought for is simple and does not cause any prejudice to the opposite side, it can be allowed. 2015, Volume 6 SEC 72. And now there is a provision in that is BNS section 232. Section 232. Yes, section 232 BNS. Yes, that is threatening a witness, threatening any person to give false evidence. That is BNS, not BNSS. This is BNSS. BNS 232 is an offense. Yes. Yes, right. So, section 232 creates an offense. BNS. It says that if a witness is threatened to give false evidence, see, he is an occurrence witness, the accused approaches him, don't tell the court, disclose that I committed the offense. So you tell the court that you did not see it. You did not see it. Then it is an offense under section 232. Section 216 BNSS says that a complaint may be filed by such witness. 216. See, a witness or any other person may file a complaint in relation to an offense under section 232 of the Bharatiya Nyaya Samhita. So, witness or any other person is entitled to file a complaint if the witness was threatened to give false evidence in favor of the accused. Yes. So this is the beginning. That is we have discussed only the first part of the complaint. What is a complaint? What is a complaint? What are the characteristics of complaint? Whether it can be oral, and what is a deemed complaint, and whether amendment is possible. And these facts we have discussed. The next class we will see the bar in taking cognizance of certain offenses on complaint. There is a bar created by the BNSS itself. So any question? Any question? When does inquiry begin and end in criminal cases? So we will be dealing with this subject later, but for your purpose, for the present purpose, the moment a magistrate takes cognizance of an offense, inquiry starts, and it ends with the recording of the plea of the accused. In warrant trial, it is recording plea after a charge is framed. In other cases, summons case, no charge is there, but plea is recorded. Particulars of offense are stated to the accused. That's all. So the three stages we have seen: investigation. Investigation ends with the police report. Inquiry starts with cognizance. Inquiry ends with charge or plea. The last step in the inquiry is recording plea. Then the trial starts. Yes. Minor typographical errors in names. Right. These minor errors can be corrected. For example, his full name was Hariharan, but he was mentioned only as Hari. Hari. That can be corrected. No prejudice will be caused. It's a simple thing. It's a simple thing. Initial mistake or date. Instead of the date 1/1/2020, he mentioned 1/1/2022. Can be corrected. Simple thing. Otherwise, with regard to the material facts, there is no question of amendment in criminal cases. The witness will file complaint before the magistrate or the police. See, a complaint is always filed before a magistrate. There is no question of filing a complaint. Legal term, we do not use. It is only an information to police, not a complaint. A complaint is always filed before a magistrate. Now, what is the last question?
So now with BNSS, jurisdiction is done away. So the question is incomplete. Joseph, I request you to type complete question, please. Then, sir, there is a question by Neha. In what way can criminal matter reach High Court if it is not a court of original jurisdiction as per BNSS?
It can reach in the form of an appeal. It can reach the High Court in the form of revision petition. Yes. Otherwise, no, High Court cannot take. Or 482 is there. 482 is there. Because 482 is there because there is a pending matter in the trial court. That arises from a proceedings pending in other courts. So original jurisdiction 482 not there.
So now
oral is there and written is later. So in some cases, the magistrates will say that you give it in writing. Give it in writing when our oral complaint is made. So there is nothing wrong in it. Magistrate will take cognizance on the complaint in writing.
So then there is a request by someone how to approach reading case laws.
Reading case laws. I will tell you one thing. See, it's really a matter to be discussed, especially this young generation. We always say that our law is dynamic. Dynamic. How a law becomes dynamic? We say that our constitution is organic. It grows. It grows. 1950 constitution, even after 75 years, it requires interpretation. It requires interpretation. The very same term which was interpreted 50 years ago, again comes up for interpretation. The law becomes dynamic, or a law becomes a law grows only when it is interpreted. If there is no question of any interpretation, the law is static. It is not a dynamic. It is not dynamic. So what does it mean? What does it mean? Unless there is an interpretation, it does not become dynamic. How can you interpret it? The term life used in the Constitution, Article 21 of the Constitution, it was interpreted years and years and years ago. But later, after a few decades, the Supreme Court said that the meaning of the word life in Article 21 is different. So the meaning of a word, meaning of a term changes in accordance with the changes that take place in the human race or in society. The context, it depends upon the context. Take the case of morality. What is morality? What is morality 50 years ago is not the meaning with which we use it after 50 years now. Morality is different. So even boys and girls, they were not allowed to mingle in classrooms 50 or 60 years ago, but now they are very free. Morality is different. So when you are able to interpret a word differently, then that means there is growth. This becomes a dynamic. But for that, who helps the courts? Advocates. Advocate gives this interpretation to courts, and that is accepted or rejected by the courts. So for what? For that, what is necessary? What is necessary is that you must be able to distinguish your case from the case which had already been decided by the court. The opposite side, it has already been decided by the court. See, the meaning of the word life, it has already been interpreted. Then you must be able to tell the court, that is not the meaning. That is not the meaning to be given in the context of my case. In the context of my case. So for that, what is necessary? You must know the facts of your case as well as the facts of the case which was decided earlier by the court. It follows that. This software will not help you in interpreting laws. Software, what is the problem? It is only a search engine. Don't become a slave of this software. It is a search engine only. If you find out some dictum in a judgment, read the entire text of the judgment. Then compare it with the facts of your case. See whether that dictum can be applied in your case. If you are not able to make a comparison of these facts and make a distinction between your cases, you don't have legal mind. So legal mind means you must be able to compare cases and make a distinction between the two cases and tell the court, see, that decision will not apply to my case. The facts are different. So a different view has to be taken in my case. So that is the duty of an advocate. And never become a slave of this software. Read the entire text of the judgment. Then only you will be able to give an interpretation, a new interpretation to the court. Yes, that is how our law becomes dynamic. Yes. When a complaint is made before a magistrate and he orders police to investigate, there is no question of taking cognizance, because the magistrate has no, only when the magistrate decides to take the case by himself, deals with the case himself. Here he is sending it to the police. There is no cognizance. It is a pre-cognizance stage. Yes. Any more question? Otherwise, we'll meet on Monday. So Monday we will start bar of taking cognizance. Bar. See, we have seen that magistrate can take cognizance if the allegations constitute suo motu cognizance. Say there is no question of the magistrate taking suo motu cognizance in a criminal case under BNSS. But contempt of court is different. That is a contempt.
Sir, the question is in context of High Court.
That's why I told you. High Court can take suo motu contempt case. That is under the Contempt of the Courts Act, not under the BNSS. BNSS, there is no provision. Ordinary IPC offenses or other offenses. Yes. But you know that in civil cases, there may be, there are instances where the High Court acts as a court of original jurisdiction, especially election petitions. MPs and MLAs. Election petitions are filed before High Court, original jurisdiction. No other court can enter because of Representation of People Act. It confers original jurisdiction on High Court. Otherwise, it's Section 15 CPC. It should be instituted in the court having or the lowest grade. Yes. So the next topic we will be considering High Court as well. I know that Bombay High Court has original jurisdiction at matters. I know civil matters, right? Because I was a student in Bombay Law College. I was a student there. I know it. Yes, in Kerala we don't have original jurisdiction. Yes, but certain High Courts have. Even Madras High Court had. If a complaint is filed at an outpost, cognizance of information, police does not entertain it. No, because he is not an SHO there. He will send. There will be a diary and he will be sent to the SHO. When the information is received by a police officer at the outpost who is not a SHO, he will send the accused to the SHO. That is the procedure. Because only an SHO can register a case. A police officer at the outpost is not the SHO. There is no SHO at a police outpost. Which provision of BNSS will apply? Because that is for this outpost. See, the section itself says that information is given to an SHO, police officer in charge. Then it can be oral, we have seen. The police officer shall reduce it in writing and get it signed. Section 174. Yes. So, can High Court directly conduct trial like Telgi trial? See, under the CRPC or BNSS, High Court has no original jurisdiction. Under the BNSS, I said under the BNSS, there may be other statutes like Representation of People Act, etc. Otherwise, it is not. Yes. So we have heard about locus standi, especially in civil cases. In criminal cases, whether this principle is applicable, whether the complainant should have a locus standi. That is the next topic we will be discussing tomorrow. Sorry, day after on Monday. Locus standi. Okay. Thank you very much. Good night. So if you have more questions, you can ask on Monday. Yes. So thank you very much. Good night.
Thank you, sir. Thank you, everyone. Good night.
Good night. Good night, Rahul also. Yes, everyone, good night.